I can docket the case. That's not a problem. If you want to have it, I mean, the court is allowed to hear emergency ex parte orders for. I mean, the bar, admittedly, is going to be very high to show that if the court doesn't act, you're going to be suffering some irreparable harm. Which I don't know if you could, how you're going to be able to show that in an administrative claim.
Everything is in there, sir. Everything is
Okay,
in there.
that's fine. Okay, I'll hear
Just
you
read
on
it, and
that.
everything is in there.
All right, I'll hear you on that shortly. What we're gonna do then is, because I feel like that hearing is gonna take some time, I want to give the opportunity for the people who've been waiting for expungements, and then I'll give the bench to Justice Techie. He can hear that the other emergency matter, and then we'll come back to you and do the administrative claim. So if you want to like do something else for a half hour or so, the court will hold you harmless until that time, or you can stay. It's your choice. Okay. All right. All right. So we are going to go. Oh, thank you. I appreciate this. Okay. We're gonna do some expungements while we wait for the next emergency hearing. If you have an expungement, if you could just start forming a line in the aisle, um, that would be greatly appreciated. Actually, Mr. Clerk, let me just do yours first. Just get that out of the way. Okay. All right, Mr. Clerk. I guess you're not Mr. Clerk for this. Okay. Calling case ex parte, Hellenic. Mr. Hellenic, rather. You have currently one record. Last date was March 17th, 2026 for evasion. March 17th was 7/14, 20 days ago. The court finds that you meet the requirements in terms of the time frame and that you're in good standing with the community. Therefore, the court, it is this 6th day of April 2026, the Superior Court of Ridgeway for Ridgeway County hereby enters an order directing the records be expunged and the petitioner's record to be cleared. Okay, thank you. All right. Okay, next, that Kuma guy. That Kuma guy. Do you have a mic, sir? Do you have a mic? Okay. Okay, Mr. Clark, can you swear him in, please?
You solemnly declare under the penalties of perjury the responses given and the statements made will be the truth, the whole truth, and nothing but the truth.
Okay, thank you, sir. I'm gonna review your record, and then I might have some questions for you. Okay. Let me begin. Taking a look here. So, Mr. Guy, it looks like you have. Sorry, that was the wrong person. No, Solanic. Looks like you have 3 citations from March 2nd. All of them are from March 2nd for disorderly conduct, aggravated extortion, and littering. Okay, these are quite interesting. The court would note that the disorderly conduct citation's description is, quote, stupid park ranger, I hate you. The court would also note that the aggravated extortion citation is described as, quote, I hate you. And the littering citation is described as, quote, shame on you. The court is not able to assess probable cause in an expungement hearing, but the court would just take judicial notice that those were the descriptions filed with those citations. Looks like the time period has been met. Mr. Kuma, how have you shown good standing in the community, sir? Well, that's fair enough. All right, is the 6th day of April 2026 of the Superior Court of Ridgeway for Ridgeway County, having considered the statements made and responses given by the petitioner, that the time period having been met, of 10 days for a citation, and that good standing in the community has been shown. The court orders that the petition be and hereby is granted, and that the records are to be expunged. Okay. All right, let's do the court. Thank you, sir. All right. Do we have? Okay. Madam Chief Public Defender. I'm sorry. Did I not bring you up here? I apologize.
Howdy, howdy, howdy.
Madam Chief Public Defender, can you explain to me why the individual sitting to your right is wearing a top hat in the shape of a birthday cake with 3 candles sticking out of it?
I believe it must be his birthday.
Okay, the court would note that is not usually attire worn to court, especially if you're going to be representing indigent defendants, or indigent defendants rather.
I think if Mr. Gardai can show up covered in yellow paint, I think
This is religious, ultra-Orthodox Jew. This is my religious
Well,
wear.
If he was representing the office of the public defender, or he was representing a party, I would give him the same warning, but he's appearing pro se today, so that's kind of his choice.
is there a dress code that the court requires?
The court will be entering an administrative order shortly to make one, if that is what is needed.
I don't think it's needed, but I mean, I can't control what you do. It's your court, I guess.
Okay, the court would just take note of the attorney's attire and would strongly encourage him to wear a suit, or at very least a tie to court. That seems like it would be the most appropriate.
Is my my shirt, which says #represent, detailing my pride in the public defense office, is this inappropriate?
It's more appropriate than what he's wearing. I prefer female lawyers to wear something more professional, but it's not exactly as soaring as that.
I will say, and I do ask that the court take judicial notice that the pin says that he voted, so he's highlighting his civic duties that he's performed for this state.
If there's no one doing anything, can we go to my case?
We're waiting for Justice Techie to come back.
Okay.
Okay.
Justice Techie's the one who issued that, by the way.
It's fine. So he can do it as a motion to reconsider, or I mean, there's
I'm
nothing.
just letting you know, and I'm the one who applied for it.
That's fine. I mean, I think it's an ex parte order, so I don't think you get arguments, but
Unless he lets me.
okay. Do we have any other short hearings? Do we have any other?
I have something.
Okay.
Can I get a restraining order from Zolaz please?
No.
What about from Zone JJ?
No, sorry.
Can I get a restraining order from him?
No.
Like, for him to not get close to me in game.
No.
We're not.
I'm not asking you. How about you?
That'll be denied,
shut that mouth
sir.
of yours? We're
not doing
Mr.
that.
Chen, haven't you
If you
said
were-
if he makes one disrespectful comment, he would be held in contempt? He just told me to shut my mouth before your court.
And you keep interrupting me.
That
Hold him
doesn't
in
matter,
contempt.
Mr. Gardai.
So can you hold him in contempt? I'll gladly be
He's
held in
yelling.
contempt if he can be held in contempt too.
Okay, Mr. Zolaz, you are not helping the problem here. Okay, every time he interrupts you or he interrupts me, you start interrupting as well. That does not.
We're only
solve the
moving
issue.
properly for sanctions, Your Honor.
Then you can make that motion. You can't keep interrupting me and him too, because then there's 3 people talking over each other instead of 2, and that just makes the entire thing take longer. Does not
Well,
help. It's just,
Just
there's
cut
no,
down
there's no well, there's no excuse to that.
if you
does
cook
not
the steak
help
a little longer, it
effectively.
doesn't hurt.
Yes, oh my god. Not helpful at all. Okay,
I'll move for contempt, please.
okay, fine. You know what? Here's what we're gonna do.
Objection.
Once we're done with all of this, okay, we'll have 2 order to show causes. But unless and until that time happens, not dealing with it. Okay, we got bigger
you.
things to deal with until then. All right. All right. Do we have any other expungements or probable cause hearings? Do we have anyone in lockup?
Can I have my case docketed?
Yeah.
Both of them, please.
Mr. Kirk, do you know how to docket cases on the website yet? Did I show you how to do that? Mr. Kirk?
Your Honor? Sorry.
Do you know how to docket cases on the website yet? Did I show you how
I
to do
don't
that?
have permissions on the website, Your Honor.
That is an issue. Let me fix that. I think that would be helpful. All right. Allow me to give you permissions, and then we'll. Okay. Does any of your staff need permissions as well? while I'm
Yes,
on here?
I can give you a username if that helps.
Yes. Okay. All right. I just gave you permission on the website. You should be good.
And the other name, I just forwarded you the name of one of our deputy clerks.
Actually, you know what? I'm going to give you administrator since you're clerk of the court, so that you can
How did
give
this guy
other
just
people
walk in,
permission.
man?
Okay. Oh yes, I see it. I apologize, Mr. Ghost. Please, let me give you permissions. Oh, you're put as a state attorney. Let me put you as a judge. Okay. All right. Great. I'm dead. Justice Techie, how much longer do you need, sir? No rush. I just
I've
want
been
to.
informed by Mr. Toby that he is no longer able to argue this matter this evening, so we will be not having a hearing.
Okay, thank you for letting me know. All right, then in that case, Mr. Guard, I guess we will hear from you.
Okay. Did you react?
Let me do that. Okay, I'm gonna call us into recess until 8:18. Okay, that gives me 5 minutes to read the complaint and to docket this case. We're gonna come back at 8:18, and I'm gonna hear, Mr. Carter, the specific arguments you're going to make about why an ex parte emergency.
Well, unless if you docket it, sir, if we can just summon the Zolas real quick.
We can't summon him to a hearing the same day. That wouldn't be fair.
I mean,
No.
he's right here,
I
though.
will waive the summons. I will gladly appear.
You're voluntarily appearing.
Yes, I will appear.
Oh, okay then. That's fine.
I'm
Okay,
very confident I will
So we're
win
now
this,
on the less
so-
stringent standard, correct?
No, I'm a very confident person. I'm very confident I will.
That's
win
good
this.
for you. That's good for you, man. Good for you.
I don't need any way. I don't need any summons.
That's fine. Okay. Then. All right then.
So we're on the less
we're gonna
stringent
put that all.
standard now.
We're gonna put that all on the record in a second. Let me just get a case number and start there.
Sure.
Hold on.
Take your time, Mr. Chen.
Okay, that's fine. But just so I have this clear, the state is waiving summons and is voluntarily appearing at a temporary restraining order hearing on behalf of the defendant. Is that correct?
Correct. And we
Would it be a
will.
preliminary injunction?
I'm sorry.
Wouldn't it be a preliminary injunction since they're here now?
Oh yes. I'm sorry. Preliminary injunction hearing. But yeah, that's okay. All right. So if the state's willing to do that, I mean, the state, of course, does not have any obligation to do that. But if they're willing to do that, that's fine. Mr. Gar, I don't see your complaint anywhere in here.
It's let me get.
When did you file it?
Filed it yesterday or today.
Oh, I see. Okay, let me assign it to
James
myself.
Garda v. RCSO. There's two. There's James Garda v. Zola as a CFL, and there's James Garda v. RCSO. This is James Garda v. RCSO.
Okay.
This is the VRCSO one.
Sorry?
Am Am I looking at this
Okay,
right? Admin claim RCSO 2.
Is the code 5477?
5477. Okay. Okay, and this is.
Dude, where are the cops at, man?
CCS, what's
Who's
going on?
filling these fools in?
What's going on, CCS?
The courthouse appears to have been taken over.
Yeah, there's about 5 shooters in the lobby. Nobody opened the doors.
Okay, all right. We're in recess until such time that the courthouse is brought under control. I hope someone's clipping this and submitting to the Department of Justice. That would be appreciated.
Our tip line's open.
And
We've submitted many
court's
many
open.
cases today. We've submitted one against James Garday.
Notice how the one you submitted against
couple
me
other
isn't even a
people.
true bill. Like,
we are
notice that.
we are moving
notice
for the fullest prosecution of all these criminals in our state.
Oh,
I'm
you're
glad the
glitching-
Department
you're
of Justice.
glitching in. So, and
Thank
notice
you
how
for
the
your-
one you submitted against
Thank you
me
for your
isn't even a
gladness,
true bill,
Mr.
sir.
Chen.
I'm glad that our Department of Justice is protecting our community. That is its goal.
Zolas, I heard the Senate is talking about impeaching you.
Okay, that is not a license to say whatever you want.
Court is in
We're-
We're
recess.
gonna move for contempt. Outrageous.
You
Hey,
said we were
we're-
in recess.
We're not in session, but that doesn't. Basic
If
These
it's
human
a rare
inflammatory
recess,
comments. This is purely hearsay.
It's not hearsay. I have direct confirmation.
The court is in recess. Can we stop talking, please?
Yeah. Thank you.
Thank you.
I
Please,
think that means
gentlemen.
you're not supposed to talk either.
That means both of you can shut the fuck up. Oh my god, sorry.
No, the clerk's right.
We have a spicy clerk.
Where are we going?
The clerk is a little
Bro.
agitated.
Okay, have we secured the courthouse yet? No, looks like not.
Oh.
Oh,
Let's make sure.
like where's this guy
Okay.
taking me? Some guy offered me a ride and just tried taking me all the way to Milton.
Are
Can we
they
get mod
renovating?
protection on this courthouse, please?
That would actually be helpful, but
Why are you shooting me, bruh?
He's down
Are
there.
they renovating?
I'll just glitch
She's
into
down
the
there.
back room.
Bruh.
I'm gonna go ahead and issue a mod protection for it.
Any
Thank
officers
you.
help me?
thank you, Shadow.
Are there renovations happening in the room next door?
Impeachment
Keep
against
glitching
me.
in the courtroom.
Oh my god.
Our room has been taken over.
Just a reminder, if you are a bar certified attorney and you are convicted within a court of law for a felony, you will be disbarred.
What
That
did
goes for
I
any-
just
any
say,
criminals.
Zolas?
Any criminals that are
Judge,
prosecuted
contempt him.
within our-
Contempt him right now. Contempt him right now.
Why did you open that door, you idiot?
Any criminals prosecuted will be held to the fullest extent. Are we still
My name
dying
is
inside the
Tyler.
courthouse?
Yeah. All right, we're we're still in recess.
There's thugs everywhere. Like,
Ladies and gentlemen, hello. I've
Can we get a
arrived.
ban on Random Garcia?
There's
please?
King
Shooting-
Von
shooting up
on
courtroom?
the
Can we
ledge
get a ban
up
on
there
Random
with
Garcia,
the
Shadow
gun.
Culture?
Okay, all
Can I
right.
get a name?
Random Garcia, ban him, please.
Okay.
If I didn't see the notification in the corner.
King Von just shot me in the courtroom. Please.
On.
We're gonna ban on Brian Murphy, please. Ban on Brian Murphy.
Finally.
Hey, can we get a ban on James Garday?
Okay.
Second.
Why are you
Can we
even
get a
here?
ban on Arthur Chen, please?
Hey, be quiet. Okay, all right. Looks like the courthouse is secure. Let's have everybody come back, please.
Have you reviewed, Mr. Chen?
I have reviewed the file. Yeah.
And just to make it clear, are we only hearing this as a preliminary or both the TRO? Which one?
This is a preliminary, sir.
Well, it is a preliminary.
So we're not having a
Case
TRO.
docketed, Judge.
All right. Mr. Clerk, has the case been docketed yet?
Oh, Your Honor, I'm having some difficulty with this website.
Oh, no worries.
Can we get the siren turned off, please?
Maybe slash initialize in the Superior Court Discord. Okay. All right. I think we're still on the record, right? All right. We're back in the record, Mr. Kirk. Can you just call the case?
Indeed, I can, Your Honor.
No.
In the
Okay, really? Judge,
Indeed.
that's another outburst by Mr.
Yeah,
Zola.
please let me into the courtroom.
Just interrupt the
Can
clerk.
someone
This
let
is
Can
contempt.
someone let him in, please? Okay, thank you. All right.
Can
Okay,
you get off
alright.
my side of the table, please?
Take a seat at the right tables. What are you guys doing?
What are you doing?
I'm the petitioner.
Hey, it's supposed to be from the judge's point of view, petitioner versus respondent, but okay.
You know what? We're fine here.
Is it?
It's okay.
Okay. Yeah, that's fine.
Okay, here we go, gentlemen. In the Administrative Court of the State of Ridgeway, James Gardi, the Ridgeway County Sheriff's Office, case number RSC-CV 5477.
Okay, parties entering your appearances, please.
James Gardi, home of Pro Se.
Laws for the state.
Okay, all right. Matter before the court here today is an administrative claim filed on an emergency basis by Mr. James Gardi, seeking review by this court over administrative leave imposed by him by the Ridgeway County Sheriff's Office. I see that counsel for the state is present. Are you going to be appearing today and waiving summons?
Yeah.
Okay, that's fine then. All right, the court has had a moment to review the filings submitted in this case. What we're gonna do is I'm gonna allow 5 minutes on each side to just make specific arguments, and I'm gonna have some questions for both parties. Okay, so petitioner, it's your motion, so I'll allow you to go first. Okay, this is again on a preliminary injunction.
Yes. Okay.
You can begin, sir.
I'm sure we all know the 4 prongs, so I won't go through those. But first, I'm likely to succeed on the merits because this administrative leave by Zolas and instituted by RCSO. First, because administrative leave. Well, first let me make it clear. Administrative leave is suspension without pay, right? And that automatically implicates a property interest in employment, and that property interest is created by statute, and that statute is it's 2 our stat section 4101, which states all persons who maintain good behavior shall have the right to employment. So based on that statute, a property interest is created in employment, and as I've cited in the
I'm so sorry to interrupt you, Mr. Gardy, but how is this not barred by collateral estoppel?
how is
Because I
it barred?
believe I've ruled on this multiple times in other cases you've filed
that's
already.
incorrect. That's
Your
incorrect.
Honor, you've ruled in a PPD admin claim for Mr. James Garde
That's
in a matter
incorrect.
like this.
That's that. First of all,
Okay. No. Okay. First off, Mr. Solis, please don't interrupt him. Second off, okay, can you also focus your arguments on why collateral estoppel does not bar this claim? Because I vaguely remember hearing 2 or 3 other cases that you've brought with the same property interest argument, and I remember denying them. So if you could help me understand why you're not barred here as well, that would be helpful.
Sure. Well, that first of all, those were TROs. It's not a judgment on the merits or anything that would stop me from presenting something like this. And second, if I recall correctly, first, I don't even think there's any record of those cases. And third, if I recall correctly, those cases were denied because of irreparable harm, which the situations have changed here, and the situation completely changed here. And in my opinion, the irreparable harm prong is met. So that's why I would not apply. Does that answer the question?
I'll have some more, but keep going.
Okay. So so first is the due process thing, and because a property interest is implicated and deprived, you need to, before you deprive a property interest, you need to follow procedural due process. And like the motion states, that includes a form of a hearing. And many courts have also concluded that where, quote, where an employee has a property interest in his job, a suspension can result in the deprivation of the interest and cannot be imposed without the protection of due process. So I think on that basis, I'm succeeding on the merits on that, but also because the attorney general doesn't even have the authority to place officers on administrative leave.
Oh my God.
What was done here is that a rogue attorney general. Well, first the statute. The statute says that a person may be placed on administrative leave for no longer than 9 days. However, a person may be put on administrative leave longer if there is a criminal investigation supplemented by order from the attorney general for a person to be placed on administrative leave. So, someone needs to be on administrative leave first, because if the key word here is a criminal investigation supplemented a criminal supplemented by order of the attorney general, right? So that needs to supplement the 9 days. So on that basis too, like I explained in the motion, the merits are succeeded. And second, going to the irreparable harm. First of all, I have a housing agreement with my with Sage 03X, and I used the job at RCSO to pay that housing agreement. And having been Toby, shut your bitch ass up. And having the
Oh, Your Honor.
Can you not interrupt me, please? I'm talking.
Hey, you need telling somebody to shut their bitch ass up is not acceptable behavior.
I didn't mean to say that on mic. My fault. I didn't mean to say that on mic.
Anybody else, Your Honor, that would be contempted.
I did not mean to say that on mic. Come on.
Should be contempted.
That okay? I'm gonna make a preliminary finding that contemptuous conduct is occurred pursuant to Rule 48. We will have a hearing on the order to show cause at the conclusion of these proceedings. Okay. All right. Please continue.
Okay. So I'm likely to not suffer irreparable harm because because like I said, I have a housing agreement with Sage 03X, and that housing agreement, I use RCSO to pay the money for the housing agreement. I live paycheck to paycheck. And
Do you have a lease?
Yeah, it's a verbal lease, sir.
It's a verbal lease. Okay.
That's as binding as any written lease.
I know that. Trust me, if he doesn't have more than 4 units, he doesn't need a written lease. But that's
okay.
fine.
So what we have there is that, yeah. And so I'm gonna become homeless. Does the court really want me to become homeless on the streets, begging for money, begging for food, while I sit there and starve? No. That's irreparable harm right there.
How much is your rent?
It's I believe it is 15. It changes every now and then, but right now I think it's 15,000.
15,000 per what? Per month? Per week? Per day?
Per week.
15,000 per week. Okay. All right.
And yeah, that might change tomorrow because we do have a clause in our verbal agreement that he can change it at any time. So let the record reflect that. And at first, and that's only I'm only bringing this rent thing because any claim of a deprivation of a constitutional injury, as I've cited in the case, I've written like 2 paragraphs of this in the case, how any let me get the quote. It is well established that the deprivation of constitutional rights unquestionably constitutes irreparable injury. So right here, what's being happening is the RCSO and the DOJ and ZOLAS are depriving my Fifth Amendment right to procedural due process in the course of depriving me of my property interest of employment. And I writ a whole whatever it is, so I'm sure the court can read that. But and next, the balance of equities and hardships. There's no harm done to the RCSO by letting someone who's been unlawfully deprived of his position back to duty while I'm standing to gain my income back so I can pay my rent and not be homeless and restore my constitutional rights. And obviously, it's in the public interest because it's not it's not in the public interest to let a rogue attorney general and RCSO go around and suspending every single law enforcement officer in sight just because there's some sort of criminal investigation without the due process, of course.
Yeah, we're not going to refer to the attorney general or anyone else's rogue without findings. Right?
Without what?
You know that we're not going to refer to the attorney general or anyone else as a rogue person without.
Well, I'm just saying, like, hypothetically.
You
Okay.
get what
I
Your
mean.
Honor, he's using this as a
Okay, he's
defamatory.
interrupting again. Come on. Is that not
if he does that
contempt?
one more
Can we
time,
get a
we're going
preliminary
to
finding on him?
countersue.
Solas, come on, really?
These
I
are
was telling you
defamatory
no.
statements.
Judge,
Okay, then you can address that with him at your own time.
Okay, we will countersue after this hearing.
Can we get?
Okay. If I'm telling him to shut up about something, I don't need you to jump in too. All right? I've
My
said that like
apologies.
3 times at this point. Goodness. All right, Mr. Guard, I apologize. Do you have anything else you need to? Any other arguments you'd like to make?
No, that's it for now. I welcome any questions. And also, I move for. Can we get a preliminary finding of contempt on that for Zolas? Because you did the same thing to me, so I think it should be done to him.
Yeah.
Okay. May I be? Or are we just gonna move on? Or
All right, we're gonna. I'm gonna issue an order to cause and make a preliminary finding pursuant to Rule 48. We'll hear both of the contempt petitions after this is done, but I'm not really worried about that right now.
Your
Okay,
Honor,
thank you, Mr. Guard. I appreciate your arguments. You can take a seat. State, I'll hear from you now on the arguments, specific arguments why the preliminary injunction should be denied.
one second, sir.
May I make a statement? Like a comment.
About what?
About what he's doing.
If it's not relevant, I'm not going to be happy. So better be good.
Well, it's low key relevant, but it's kind of like it's like on the border, like kind of.
Then no. Oh, you can, but if you're just going to make me mad, that's probably not a good idea.
It involves the use of ChatGPT and making his legal argument.
Hey, that's enough.
I didn't say he did. I was just questioning.
Not okay. Not okay.
What did he say? I had my headphones off.
He said
Don't
that
worry
you were.
I didn't
He
say
made a
nothing. I
comment
didn't say that,
is
Joe.
not appropriate and is not to be said, and is going to be, and that comment's going to be reviewed at our order to show cause hearing when we're done.
What did
Don't
he
Your
do
Honor,
that
could you enter a second preliminary finding at this stage, just to ensure that
Who are you?
everything's on the
Who
up
are
and
you?
up. I'm a contractor for the government. I'm here.
Who are
That's
you?
false. That's false.
Your Honor, we permitted him as a contractor. for
That's
the
false.
state.
He's in the public defender's office.
Why
That's
didn't
false.
you enter your appearance then?
Well,
I
Your
hope
Honor,
Perhaps I was on mute.
you must have not heard him.
That's a lie. They're both conspiring to.
Can we move on? I don't know what he said. I don't know what he said while I had my headphones off, but
Your Honor,
Can I
I've been
make my
sitting here the whole
statement?
time. I've been here the whole
Hey.
time.
I'm entering another preliminary finding on both of you. Okay, Mr. Feelings. Okay, Mr. Feelings is counsel for the government as well. All right, Mr. Solas, please
Thank you.
okay.
present your argument.
Obviously we're reviewing this whatever petition this you could call it.
One second, Judge.
under-
I'm sorry to interrupt. Judge,
Okay, really?
May I? No. In regards to Mr. Feelings,
Your
Mr.
Honor,
Feelings
come on.
Mr. Feelings actually, if I recall correctly, he represented me in a matter with nearly the same identical argument. So I
Your Honor,
request
you
that
just
disqualify.
contempted me for interrupting him, and he just interrupted me in my opening
Mr.
speech.
Gardai, if you want to file
it
a
goes to his
motion,
disqualification.
Mr. Gardai, if you want to file a motion, you can do that, but I'm not worried about it because he's not making the arguments right now.
Okay,
Okay.
well, when he does, I would love to.
Then you can do that at that time. You two, you both need to stop interrupting each other. Don't do that, okay? If you have a problem, you can stand up out of your chair, and I will know to call on you. But he's making arguments right now. Let him hear him out, please. I apologize, Mr. Solas. Please continue.
Like I was saying before I was really interrupted, we are reviewing this petition under the winter test, Your Honor, the 4 prongs. Your Honor, Mr. Gardet has stated he would succeed on the likelihood of the merits. he hasn't shown at all that he's clearly likely to win in this case. Your Honor, he's disputing the claim that the Attorney General does not have the origin authority to place a police officer on leave through directive. That's absolutely false, Your Honor. You've yourself ruled against this very thing in a PPD administrative claim case, which the state was the successor in that case in a ruling held before duty court with you presiding. Furthermore, Your Honor, even if hypothetically, if James had he said a property interest, that does not entitle him at all to any sort of relief. I can pull up a case law here. We have Board of Regents v. Roth, 1972, where it only recognizes that when a property interest exists by state law, it doesn't. It holds that. I'm sorry. It does not hold that every allegation alleging deprivation automatically requires a reinstatement.
Is that Board of State Colleges versus Roth?
Should be.
I don't think that case says that, sir.
James, I'm not going to tell you again. 408 U.S.
Yeah, 408 U.S. 564 1972.
Okay, I'm reading that. Thank you.
Yep, and one second, Your Honor. Going back to the four prongs, irreparable harm here. The plaintiff claim for irreparable harm. It absolutely fails here, Your Honor, because he's alleging economic or monetary losses stated with whatever property he was paying rent for. Your Honor, if we take a look at the landmark case of Sampson v. Murray, which is a preliminary injunction related a holding case.
Is that 1974?
Yes, it is at 415 U.S. 61 1974. Yes.
Okay.
And then, furthermore, Your Honor, that specific case addresses the loss of employment with monetary loss and income. And that case has directly held that those it's monetary loss of employment and whatever made is through income through their job is not irreparable harm, because those the things affected by those alleged harms, they could be addressed through a damages or a civil lawsuit, not through a preliminary injunction. And also, Your Honor, the plaintiff his own claim, he seeks relief. One second, Your Honor, let me. Yeah, Your Honor, everything, the demand for his relief in the administrative claim in which he's seeking is the same as in his preliminary injunction. And courts have, I believe, generally held that when damages are available to be judged upon on a trial by court, that preliminary injunctions shouldn't be issued on the same request of relief as they are in the administrative claim. Your Honor, furthermore, whatever argument Mr. Gardet made for his rent with Mr. Sage, and showing that his RCSO income is reliant on him paying rent for his house. Your Honor, he's not shown this court any form of mispayment, nor was he evicted as we speak now, or any termination of his contract with Mr. Sage. And that goes back to our previous point, how monetary harms are compensatable at a trial through a civil court.
Okay.
And then finally, on the third prong of the Winters case, the balance of equities, Your Honor. The plaintiff, Mr. Gardet in this case, he's asking you basically to reinstate him and remove the leave order before we've even entered a case, which this directive should be challenged upon, not by a preliminary injunction. Furthermore, Your Honor, we're deciding the merits of this entire case through a preliminary injunction before we've even established factual arguments for this case, and before the merits are decided upon by an honorable court. This one second, Your Honor. Your Honor, just to sum it up here, to wrap it up, Mr. Gardet, he fails all four of the Winter factors. He does not succeed in any single one of those factors. And furthermore, we'd like to re-bring up Your Honor, I'm going to cite a case here, the Ridgeway Civil Court case number 8708 of State of Ridgeway and the Ridgeway County Sheriff's Office v. James Gardet. I will forward that to you through your direct messages, Your Honor.
Can you
I will also forward it.
case?
Yeah, I will forward it to James too.
Okay.
I already know it.
Appreciate it. Thank you.
Okay. And Your Honor, there was a 1 second. Your Honor, this honorable court has held that, and I quote, the defendant's interpretation would prevent the state's chief law enforcement officer from suspending an armed deputy under criminal investigation. This court declines to adopt such an interpretation. Your Honor, that completely undermines his claims that were made here today, as well as failing the four-prong test. I yield, Your Honor. Thank you.
Thank you. All right, last word, Mr. Gardet.
Okay. So I'll break it down one by one. So first, let me get this here. First, his entire argument against irreparable harm is based on that Samson case, and what the Samson case said directly is temporary loss of income, ultimately to be recovered, does not usually constitute irreparable injury, and it does note that there are extraordinary circumstances which it would. And here, and first, that's only for like the rent argument. First, the extraordinary circumstances are present here, where I'm going to be homeless on the streets without a home, without a bed, without a roof over my head, without anything. And second, as to his thing that I've showed no lease agreement. I moved for a preliminary injunction, and I have a verified affidavit in the complaint, and so that's all I need to do this preliminary injunction. There is no fact-finding process that needs to happen here, like he's trying to say. So, by his argument, no one can ever move for a preliminary injunction at all. And also going back to Samson, Samson was not necessarily a pure like constitutional rights case where I'm alleging a deprivation of property interest because of a right to an employment like I am. And Samson really, what it was about was if I recall correctly, it was a procedural irregular. What's the word? Irregularity. Is that the word, Judge? In the discharge of the person. Uh, and what happened there was that the woman being discharged said that they owed more process in how it happened to being discharged, but there was never a property interest statute or right asserted like there is in my case here, where there's a statute that directly creates a property interest in continued employment. And so because I have because the case differs so much. First, like I said, the extraordinary whatever, and but because the main hinge on my irreparable harm is the constitutional injury, and I've cited a billion cases in my claim that simply an allegation of constitutional injury alone is sufficient for an preliminary injunction in the irreparable harm prong. So that's that. And also
What was the reason for your administrative leave? Was the attorney
pending criminal and misconduct investigation.
okay?
And second, going to first of all, I still assert that the attorney general has no authority to place people on administrative leave, and that's an easy reading of the statute. I mean, we literally have people in general chat in the state of Ridgeway saying that it's not possible, and these are laymen, right? And another thing is that oh, did you want to say something? I hear something.
I didn't say anything. You can keep going.
Okay, so what is it? Let me get it real quick. The case here, let me pull up the order that he cited, State of Ridgeway and Sheriff's Office v. James Gardi. I moved to dismiss this case because the complaint lacked the allegation that I was ever on administrative leave. It only said I was ordered on administrative leave, but never placed on administrative leave. And if you go and read, I also, just for the fun of it, I brought up the argument that the attorney general has no authority to place an individual on administrative leave. But in retrospect, the court could have never actually legally ruled on that argument because that argument was more appropriate for a motion to or not a motion, excuse me, for a summary judgment or motion on the pleadings. So that's that. So I'm using that case is literally you can't use it. Plus, if you go look at the case itself, there is zero analysis by Judge Rummy on this case. It's literally scraping the bottom of the barrel, and there's nothing here. And so, yeah, that's that. And yeah, I mean, he basically admitted that I didn't get any due process or whatever, and in placing me on administrative leave, and I mean that's a literal admission because that I have a property interest in continued employment, and he didn't give me process before I was deprived of that property interest, and so the only remedy here is for the court to institute me back, and if they want to do it again, if they want to place it on me again, they can go through the proper due process procedures.
What would that due process look like? What is your idea of due process in a situation?
Well, my idea would be that it's like I said in the cases, there needs to be a hearing, a notice of the charges, and an opportunity to respond to the charges. And in my case, that would have to be ultimately a referral to internal affairs, and internal affairs would handle the situation because internal affairs, and this is supported by the entire statutory scheme of the administrative leave statute, is that internal affairs is the only people who can place people on administrative leave, right? Even if you say that the attorney general has the authority to issue standalone administrative leave, the statute literally says he can only order administrative leave. It doesn't say he can place people on administrative leave. That right to place people on administrative leave is only reserved to internal affairs offices. And so what would have to happen is whatever grievance the attorney general has, he should report it to internal affairs through the proper channels, and internal affairs can start that process and determine if I deserve to be, whatever, suspended or whatever. But also another thing, I think placing someone on an indefinite administrative leave, then them never knowing when they can get off, completely cutting them off for months. I was on administrative leave for like 3 months by the Attorney General in Ridgeway, and nothing happened. And so I think that's also a type of deprivation that's impermissible.
Okay. I don't have any other questions. But do you
no,
have anything else?
Judge, I see Knott's feeling standing up, and I'd like to address the motion to disqualify, please.
Your Honor, he hasn't even spoken yet.
I mean, he's standing up. He's trying to speak.
Mr. Feelings, what is? Do you have something you need to tell the court?
Yeah, I feel that the
Can the court hear my motion to disqualify?
respondent here would be.
Hey, can the court hear my motion?
Let
to
me
not
finish
disqualify?
interrupt
my
okay.
thing first.
He's
Ask that you
I don't
not
even know
interrupt
why
me.
he's here.
Huh?
What is that?
Mr. Feelings represented me on a case exactly like this. Yeah, he has a conflict of interest.
Mr. Gardat. Mr. Gardat. He was
Plus, he's
asking.
employed on public
What
was
defender's
that?
office.
Will you wait?
I'm waiting.
Let me see. Okay, Mr. Feelings, without making the argument, what exactly are you trying to do? Are you making a motion? Are you making an argument? What are you doing?
There are a few points that I'd like to clarify because I believe that the petitioner is not accurately stating the law.
Okay, so he's made a motion to disqualify. Is it true? Is it true that you represented him? That he's a past client of yours, or?
Mr. Garda has been a client of mine at various points in the past. He is not a client of mine in this matter.
Right, but in a
And
similar
he
manner.
represented you, or you represented him rather in an identical action.
I don't recall. So that being
Judge,
the case,
as an officer of the court, I'm telling you that it was a TRO hearing, and he was representing PDO, and PDO was offering their assistance to me. Him and Violet were right there on that table, standing right there, representing me in a nearly identical matter at this, with overlapping legal arguments.
If that's the case, you are 100% conflicted out of this. I don't remember.
In fact, I think he should be referred to the state bar.
I don't believe that that's the case.
Okay. Do you, Mr. Garda, do you have an appearance line or something you can show me?
I mean, Judge, at the time, I mean, by the court's own admission, it didn't have records, but I'm sure Violet can come up here and corroborate the fact.
Okay. All right. Because I'm just gonna say right now, if that's true, you absolutely cannot be arguing the other side of it. I think everyone would.
I certainly
agree
agree,
with
but I have no recollection of any such
remember-
arguments being
Judge,
made.
I remember
Mr. Garda,
verbatim.
I asked that you stop interrupting me.
Yes.
I
seems
asked
to
that
be
you
your
not
specialty.
represent.
Stop.
Look,
What
we're
did I-
moving for
what have I
contempt,
said?
Your Honor.
4 or 5 or 6 or 7 times now. This is getting so frustrating.
Just contempt him.
He already has multiple contempts at this point. The court entering more is clearly not going to solve his behavior.
Well, maybe we should refer him to the state bar.
That's something that someone else would have to do, not me. So, okay, all right, Mr. Guard, I do. All right,
By what?
okay. So, Mr. Fillings, you're saying you're representing to an officer of this court that you were not his counsel in a similar action, making arguments for him on.
I don't recall anything of that nature. I have no records of anything of that nature. I have
Okay.
no representation agreement signed with Mr. Gardai.
Judge.
Do you? Yes, Mr. Guard. Do you have anything to
I
show
don't have
that?
anything. I mean,
If
let's
Mr.
bring up-
Gardai,
let's
sorry,
bring up-
go ahead.
please don't interrupt me, sir. Please, thank you. We can bring Violet up here. I'm sure Violet. I literally remember him standing up for me and talking about the Attorney General's administrative leave authority and how it can only supplement the 9 days. I literally remember him standing right on that table and arguing it for me in my PPD case.
Your Honor.
Yes.
And it was PDO, Violet, and Knott's Feelings who represent me. I don't even know how Knott's Feelings is being
Your Honor.
contracted by the DOJ when he's employed in PDO.
Yes. Okay, Mr. Fillings. Last thing.
I would very respectfully submit that even two things. First of all, it would be the responsibility of Mr. Gardai to set forth the standard of evidence required to move for disqualification, and secondly, that even if that question of law was something that I did brief on, that question of law has been settled by the court and is not, in fact, really in dispute here.
That's false, sir.
That's not what the argument the plaintiff's making. I mean, I think there's a collateral estoppel issue, personally, right? That the plaintiff has addressed, but I have mentioned that before, and it looks almost identical to previous petitions. So I wouldn't necessarily agree with that, but I do agree with you on the respect that it is his burden to show that he should be disqualified. So, Mr. Gardai, if you don't have anything,
Can we bring Violet up, please? And
yeah,
that's what I've been asking to do the past three times.
If you'd like to, okay.
Violet
Alright.
was co-counsel, while Knott's Feelings was also co-counsel.
So you want to call her as a witness for the
Yes.
for means of disqualification? Okay, all right. Madam Chief Public Defender, can you go up to the witness stand on my left, please?
Hello.
Can you come to the witness stand on my left, please? Okay, thank you. Mr. Clerk, can you swear her in?
Yes, I can.
Oh, he's right there. Oh,
You-
that was scary.
Do you solemnly declare under the penalties of perjury that the responses given and the statements made will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Witness answer in the affirmative. All right, I'm not gonna because it's just me. All right, I'm not gonna require you to lay as much foundation. Just get to the point.
Okay. Did you represent me in the past?
Yes.
And was it with Knott's Feelings?
Maybe one time. It's been a
Wha-
while.
it- Am I correct when I'm saying it's in a PPD case before this court in a TRO hearing where you and Knott's Feelings were sitting at that table and Knott's Feelings was making arguments for me?
In a PPD case, I don't recall. I recall representing you individually in a interview. I don't recall specifically if it was.
Does everyone have amnesia? What's going on? Oh my gosh. All right. Keep questioning her, please.
I mean, there's nothing else I can say. She says she doesn't remember, but
Yeah.
I'm telling you, I promise you, Knott's Feelings was representing me, and it's a shame that he's disgracing the state bar and himself by lying and saying that he wasn't.
Okay, then let me tell you this. There's nothing. As you can probably tell, there's nothing I can really do about that. But I would warn both Mr.
Judge,
Feeling-
if the court held better records in recording these proceedings, it'd be apparent, but clearly it has not.
I can look back at my notes and see, but I take my notes by hand, so I have to look at my book.
Mr. Feeling should be utterly ashamed of himself.
Okay, that comment was
Your
needed.
Honor. Yeah.
That comment was not needed.
Wow.
All right, here. Let me go through my notebook. Okay.
Shame, boy, shame.
You remember approximately the date of when this hearing was?
It was. I'll see because I remember I sent the claim to Boom Blast. So let me look.
Just
Okay, it was on or about the date of. Let me see. Okay, I think it was either March 8th or March 15th.
Okay.
Just for the record here, Your Honor, if I did recall, if I could recall, that I had made some kind of conflicting arguments, I obviously would recuse. If it can be shown that I did make such an argument, I will recuse. I'm certainly not here to shoot holes through the ethical rules, but I
Sure you are, buddy.
just can't recall something of that nature happening.
Okay, so it looks like, all right. I have a note here that says plaintiff's counsel feelings TRO. I mean, I don't remember what the arguments were, but it
When
does
was
look
it?
like
When was it?
you were there. I'm looking at March. This is March 15th,
Yeah,
2020.
that's the exact date I sent the administrative leave with nearly identical facts and legal arguments to the clerk.
Okay, so it does show it that we did hold. That looks like this was an emergency ex parte hearing. But it does look like you did appear. I don't honestly. I can't read most of my handwriting.
Sorry, I shouldn't. laugh
Judge,
about
I only filed one case on that day, and I can forward you the case right now.
No, I believe you. I believe you. So I don't know. I mean, if I have to look into it later, I will. Right? I really had bad handwriting. I think I was probably intoxicated that night or something. Jeez. Okay.
He needs to be disqualified. I think that no itself is enough.
I'm not gonna go off my handwritten notes only. I need something more than that. But I'm just gonna warn Mr. Feelings and really any member of the state bar that if the court were to find through its own investigation or upon some discoveries made later that an attorney willfully represented to the court material facts about their prior representations and did not disclose it, especially on a motion for disqualification, that would be a really serious issue, and there would be severe consequences for that. So I don't think that obviously goes without saying, but I think it's important to reiterate that it's an attorney's job to recuse if there's a conflict. That's what the rules of professional conduct say. So
Can I actually, perhaps
far-
if I show this claim to violates, perhaps their memory would be jogged.
sure, that's fine. It's
Well,
not
Sure,
evidence.
I'll forward it.
No.
Huh?
Ask her
Oh,
the
I
question.
just-
I sent it. I sent it, Violet.
Oh,
You recall
thank
that?
you. Let me read it real quick. Sorry.
Recall the facts of that?
Uh, Sorry, I'm reading it. Just give me a moment.
My handwriting's really. I wrote some notes down about what was said, but I can only read about.
Judge, I think the simple note of saying Knott's feelings as petitioner is counsel for me is more than enough because that means I only brought because that day I only brought one case before the court and it was that. And if he was counsel for me, then he made arguments on the matter.
I agree with you. I mean,
I mean that's more than enough.
I don't
Plus,
really.
he says he doesn't recall, and I'm telling you that he did.
Okay.
Your Honor, I believe Mr. Garda just accused me of lying.
Yeah, you are lying. In my
Oh.
humble opinion.
Your Honor.
Attempt.
Okay.
What the hell?
It's not
I mean, you should be ashamed.
enough.
Attempt.
You guys are done. I've held him in contempt like 3 or 4 times already, as I have. you,
Fifth one
so
wouldn't hurt.
We're gonna do. We're gonna deal with that.
I
later.
heard he had 8 once.
All those
Yeah.
were expunged. So
Clearly, that doesn't even do anything. So. Okay. All right. We're just gonna keep going. I don't really have the time to sit here and.
does Violet remember? Or
all
no?
of was I the judge?
Does Violet
Was I
remember?
deciding?
I mean, you make these arguments a lot.
That's what I was thinking. I was like, haven't we had 3 or 4 hearings on this already? I can't remember.
No,
Like-
no. Those were all
Hey.
denied for irreparable harm, and I'm telling you, the facts and the circumstances are different.
Okay. Well,
Plus, there's zero record of those in the Superior Court, so I don't know how you can say I'm a stop and there's no record.
I mean, I recall the arguments. You make them all the time. I don't know where
All right.
I mean, just in general.
Well, based on the personal note that you wrote of the proceedings, I would ask that he be disqualified, please.
I wouldn't feel comfortable just calling an attorney just based on my.
Well, what about his concurrent
Handwritten
employment
note.
within public defenders and DOJ? Is that not a conflict?
That would be. Well, you're not
This
being
is a
represented
civil
by the public
case.
defender.
Your Honor,
You're not being represented by the public defender, are you?
he is not.
I am in the public defender's office.
Okay, but you're not being represented by the public defender in this case, are you?
No, but he's represented me before, and your note wrote that down. So you need to kick him out of here.
Your Honor, he went to McDonald's at the same time as me.
That's inappropriate. Hold him in contempt.
That's not
move for
okay, Mr. Zolas. That is
Oh, Mr. Zolas,
unacceptable. I'm making another preliminary finding of contempt.
Oh,
to
I'm
you,
sorry.
sir.
If you didn't hear, I can clip it. Mr. Garde was saying slick stuff under not feelings' statements.
At least I'm not fast fuck like you.
All right, that's
Wow.
enough. That's enough. I am done
Contempt.
with both of you. Done with both of you. This is absolutely the most unacceptable type of behavior I have seen in my 30 years on the bench. This is absolutely unacceptable. I am so tired of the both of you insulting each other, trying to get it past me by sneaking it in on the last couple words of their sentence. Not okay. Not okay.
That's
I'm making another preliminary finding. We're up to, what is this, number 5? Absolutely unacceptable. Hey, the next person who does this will have the remainder of the hearing in lockup. I am completely dumbfounded. This is just the rules of professional conduct are being steamrolled. Unacceptable.
So,
Heck.
is he being disqualified?
I'd love to steam your role.
All right, can we get contempt for that guy, please? Did you
I'm
just say
making-
he's going
I'm
to
making another- I'm making another preliminary finding of contempt. That is just not okay.
Zolas?
He said, "I'm going to quote steam your role."
That was
Yeah,
not
Zolas. I mean,
Zolaz.
shame
Your
on
Honor.
That
Zolas.
was not Zolaz.
Your Honor,
was it that- who was
was,
That sounded like Zolas to me. That sounded
I
like
never.
Zolas to me.
I was on mute the
Your Honor.
entire
Yeah,
time.
sure you were. Sure you
Your
were.
Honor. Your Honor, that
What?
was shadow culture,
Oh, okay.
not
I
Mr.
apologize.
Zola.
I apologize on that. I thought it was the last.
I was on mute.
Okay, all right. I apologize. Then that one is that finding is vacated. Okay. Let's. Great, we're being shut up. Okay, we're gonna finish this hearing. Okay, Mr. Garde, can you? I can't disqualify him for the reason I've said. I don't have enough with me to.
That's fine, Judge. I'll get his bar revoked.
You can file a complaint if you'd like. That's your right, but I can't do it based off of just this.
Shame
And
on
I
him.
think-
Absolutely shame, Judge. He should put
All
his
right,
head down
that's
and walk.
all-
in
Your
the-
Honor. Your Honor.
Okay, Sheriff, please restrain.
What did I
Mr.
do?
Garde.
What did I do? What did I do?
What do you think you just did?
I'm just saying that he's lying about it.
Your Honor, we're gonna move for a gag order.
Mr. Garde, all right, take this type of behavior is. I just warned you. I warned everybody multiple times about this, and you decide to say these comments. Really?
Oh, my fault, Judge. I'm sorry.
All right. Keep an eye on
I'm
him.
sure, Judge.
for a
I'm sure
minute.
you can understand how it might infuriate you when your former co-counsel lies directly to the court about his former representations.
And if that is true, and you can show the court or the state bar otherwise, there will be severe punishments for that. But unless and until that happens, as I've said, and I think you know, there's really nothing I can do about it. Because he doesn't remember. You don't have an engagement agreement or retainer agreement or any documentation. All I have is my handwritten
It was
notebook.
through
that's
public
not-
defense. I mean, Judge,
Okay.
would you on the handwritten notes? Would you write counsel for James Gardner Nott's feelings if on the day of the claim being submitted and heard? What kind of coincidence is that? That's not a coincidence. That's what happened.
That's not the concern. People, the legal community is pretty small. People represent each other all the time. It's about whether he's making conflicting arguments or not for the adverse party or against the adverse
Well,
party.
he
rather.
is. The claim literally has. He's about to oppose everything that I'm saying in the claim.
Okay,
that
and
he
I
represents.
understand. Look, I understand that, and I'm saying that if that is true, he absolutely would be disqualified. I think he even missed that he would be disqualified. He doesn't remember. The chief public defender doesn't remember. I don't remember. All I have is my handwritten book. We don't have any engagement agreement or transcript to show otherwise. I'm going to do some investigation after this is done to validate these claims. But at this point, the burden is on you, and I don't have anything here to show otherwise, right?
Okay, so after the investigation, if it does come to be true that he was, would the court hold him in contempt?
Probably more severe than that, but yes.
Thank you. That's all. That's all. Okay, he can say whatever he wants. Can I be uncuffed, please?
No, you're remaining in cuffs. But I'm going to warn Mr. Zolas and Mr. Feelings. If this behavior continues, you're going to be in cuffs for the rest of the hearing as well. All right, Mr. Guard, do you have any other arguments you'd like to make?
No, I invite the court for questions.
Okay.
All right, so Zolas wants to talk again.
No, that's Madam Chief Public Defender. Yes, you can step down. I apologize for not releasing you sooner.
Oh, you're fine. Thank you.
Okay.
Mr. Chen, excuse me.
Yes, what?
Before this entire thing blew up, Mr. Feelings was making an argument to the court.
Right. Okay. Let's get back to that then. Thank you for reminding me. Yes, Mr. Feelings. Okay, deputies, you can take him back to his table. Okay, Mr. Feelings, I'll hear from you now.
Thank you, Your Honor, and thank you, Mr. Gardai, for your arguments here today. I would like to point out some discrepancies which I've found. Well, there are numerous discrepancies with the argument presented by the petitioner with respect to the accuracy of what he is quoting as case law and in statutory law. One that really is glaring in this instance is the representation by the petitioner, which I believe is a willful misrepresentation of the statute to the court, that administrative leave can only be imposed by internal affairs. That's not what the statute says, Your Honor. The statute specifically says that administrative leaves may only be reviewed in the administrative courts if the placement was not by an internal affairs entity, or B, the suspension went on longer than allowed in the statutory scheme. Nothing there contributes any kind of limits on who can issue the administrative leave. It only imposes when those things may come up into review. Here, because the administrative leave is imposed by the Attorney General, certainly it could come up into review. But the fact that it is not done by an internal affairs entity does not, in and of itself, negate the fact that he was put on administrative leave. Just wanted to clear that up and make sure we're all on the same page about what the law actually says in this matter.
Yep, I appreciate that. All right.
Response.
Yeah, so this has been a long hearing. Mr. Guy, coming up here, please.
You asking me a
I'm
question,
taking a look at a case that the court found called Gilbert versus Homer. Okay, and I'm just gonna read the overview. So it looks like from this case, an employee, he was a University of
I think I cited that, sir.
East Stroudsburg. He was an East Stroudsburg University police officer. Okay, and he was arrested on drug charges, and the state university suspended him without pay. And after the charges were dropped, the employee was demoted and he was given back pay at a lower rate. He then filed suit against the university, alleging that the university's failure to provide him with notice and an opportunity to be heard before suspending him without pay, violating due process. District Court entered summary judgment for the university. Court of Appeals reversed. Supreme Court granted cert and reversed that. Supreme Court found that the employee's due process rights were not violated because his private interest in receiving pay was not significant enough where he could receive a prompt post-suspension hearing, and that the state had a significant interest in immediately suspending him and suspending employees with police powers when criminal investigations were underway. So can you understand me how your argument today does not fly in the face of the court's holding in Gilbert versus Homer?
Yes. So I already researched that beforehand, and so what Gilbert is saying is that it's not holding that like unpaid leave is always like unconstitutional, but it's saying that a suspension without pay, as was in the case of that officer, uh, implicates due process in triggers a due process analysis. And then once that due process analysis is applied, then you have to do the Matthews test, which I cited, the Matthews balancing test.
Okay.
And so, I mean, the facts of that case are also much different from this. I mean, there is a direct statute creating a property interest in continued employment in Ridgeway, and the other side is depriving that without due process. I mean, it's plain and simple.
Okay.
I mean, I think the better case to look under this is Loudermill, because in Loudermill there was a statute that public employees had a property interest in continued employment.
Yeah, of course.
We already debunked that in the cases I
Oh
cited.
my
Judge,
God.
he's
Oh my God.
Can we get cuffs on him, please?
Oh
I
my
mean,
God.
that's what you said, Judge. You put cuffs on him.
Yeah,
If he
that's what's
interrupted.
happening. Stop, James. Yeah, that's what's happening. Please restrain him too. This is
Oh,
just.
I'm sorry, Your Honor. I was under the impression you were allowing a counter argument at this time. What is this? What are we questioning
did
him?
I tell you that I was making a counter argument? Did I? God, I'm.
Yeah, well, I'm not a troll,
I'm
so I'll
losing
apologize
it.
to this court.
And now he just called me a troll.
Yeah, the court understood that as.
Can we get a preliminary finding on that for contempt, please?
Yeah, the court's entering another preliminary finding of contempt.
Oh,
This has just been.
please
All right.
continue. Please continue.
I've heard the loud. I've heard the. I've heard.
Judge, I
the
think
Loudermill
that,
case.
Judge, I think that may I continue my argument, Judge?
Yes.
Okay, so I think another case which you have to see from the Supreme Court, which I cited in my claim, is FDIC v. Mallon 486 U.S. 230, and it says it is all, it's directly actually quoted directly in my claim, and let me get it real quick for you. It says it is also, quote, it is also undisputed that the FDIC's order of suspension affected the deprivation of this property interest. Accordingly, appellee is entitled to protection of due process of law. And that's FDI, and that's in my brief, FDIC v. Mallon. And in my brief, also, there's an entire paragraph about unpaid suspensions and the implication of property interest.
Okay.
It's under section 2, and it's it's the 4th paragraph.
Okay. All right. Do you have any other arguments?
No.
I see Mr. Felix is saying. I'm going to let Mr. Felix go one more time, and then I'm going to let Mr. Garde respond since it's his motion, and then I'm going to rule. Okay. So, deputies, can you take him back to his table, Mr. Felix?
You. Happy to see I'm the only counselor not currently restrained. We just like to brief for a moment the fact that the holding of Gilbert is clear. Just from the syllabus, quote, due process is flexible and calls for such procedural protections as the particular situation demands. And that's quoting, not quoting, or it's citing Brewer and FDIC v. Mallon, both authorities cited by the petitioner here and now. The holding of Gilbert is that the notice and hearing does not necessarily need to occur before the suspension without pay is imposed, where that suspension without pay is reasonable based on the particulars of the situation, right? A hearing at some point promptly following the imposition of that leave is sufficient under the holding of Gilbert and the associated authorities. Also worth noting, I think, is Section 3128, which details where administrative leave may be used, specifically for pending misconduct or pending criminal investigations. The due process of the administrative leave is satisfied when those investigations conclude, because those investigations in and of themselves have due process interwoven. I don't think that we need to reinvent the wheel here and start issuing preliminary injunctions. The law and the controlling statutes on these sets of circumstances is quite clear, and the court should stick to those.
Okay, thank you. All right, Mr. Gray,
Thank you.
last word.
Okay, and I quote directly from Matt from let me find it 1 second. I just had it from Matthews v. Eldridge. Indeed, some form of hearing is required before an individual is finally deprived of a property interest.
Can you which case is that?
Matthews v. Eldridge, 424 U.S. 319, page 333, 1976.
Okay, thank you.
Right, and also from the syllabus of Gilbert, it says 3 factors are relevant in determining what process is constitutionally due. 1, the private interest that will be affected by the official action. 2, the risk of erroneous deprivation of such interest through the procedures used, and the probable value of any additional or substitute procedural safeguards. And 3, the government's interest. So here, I haven't even been given notice of the. The only reason I found out of this administrative leave is because I was suspended in the RCSO group and in the Discord, and it was logged in the RCSO. No one from DOJ ever contacted me. No one from DOJ ever did anything. No one. I mean, if it was a case where you could. If it was a case, even following the hypothetical, where you could even engage in a post-deprivation hearing, none was ever given to me, and I guarantee you that none was ever going to be given to me. And that's because if one was going to give it to me, they would suspend me first, and then they would immediately contact me with the information in case. To be honest, I don't even know why I'm on administrative leave right now. I don't even know. I don't know the facts of the case. I don't know anything. And so that's that. And here let me get you another quote. Where an employee has a property interest in his job, a suspension can result in the deprivation of interest that cannot be imposed without the protection of due process. Right. So first you need to protect due process. That's Kennedy v. City of New York, number 94CV02A86 SDNY in 1995. And there's also a bunch of it's all on my claim, but yeah, I mean, it's pretty simple, very simple matter, Judge.
Okay.
And the we've talked about irreparable harm, right? So I don't need to go through that.
I've heard good arguments on that.
Okay.
Okay. I think the court's ready for a ruling. Unless you have anything else you want to add.
No.
Okay. All right. Thank you.
I had something.
I usually give the petitioner the last word, so.
Yeah, I would object to that, sir. Petitioner always has the last
Is it
word.
something?
Okay,
Is it something new that hasn't been discussed already?
No, Your Honor, we'll just it's fine. We'll allow you to rule.
Okay. All right. So, case before the court now is a preliminary injunction challenging the petitioner's administrative leave imposed by the Ridgeway County Sheriff's Office due to the Attorney General's order ordering the Sheriff's Office to do so pursuant to an ongoing, quote, criminal and or misconduct investigation. Whether the petitioner can satisfy the preliminary injunction requirements includes particularly likelihood on success of the merits, irreparable harm, and test of equities and public interest. On the merits, this one is the one where it's the most it's a little bit 50-50 for me. I think that the petitioner has some very good arguments as to the property interest and to whether whether this type of administrative leave can be imposed. I don't totally reject them. Actually, I've heard some very interesting arguments that I would like to see briefed further. But the state and the law hasn't really been developed in this area as much, especially when it comes to applying to our state statute of property interest, which the federal cases don't have. So I do understand where the petitioner is coming from. I would just note that in winter there needs to be a clear showing that the plaintiff is entitled to relief. That's on page 22. So when the legal or factual issues are unsettled or disputed or subject to competing interpretations, it's the court's view that a preliminary injunction at least should be denied for merits simply because there's no clear showing either way. I think that the petitioner very likely could succeed on the merits, as could the state. I think that there's lots of competing Supreme Court case law on this issue. So I'm going to find that because there's an absence of clear showing on the merits. I'm unable to find that the petitioner has met that test. Additionally, the other thing I wanted to bring up is that when there's irreparable harm mentioned, that generally means that there is no adequate remedy at law. And one of the adequate remedies at law that the court can impose is monetary damages. And the availability of economic damages does not meet. The petitioner is entitled to back pay if this is found to be overturned. The petitioner is entitled to sue the government for this, right? The mere fact that the petitioner will not be paid during his suspension is not enough showing for the court to show irreparable harm. And I'm going to point to Xiao Jinjiao versus Ningbu Xiu, and that's 28 federal for federal. Oops, sorry, I just clicked off the for federal 591 out of the Fifth Circuit 2001. I think that the petitioner's loss and the downstream financial consequences, such as the eviction from Mr. Sage's house, are quintessentially economic, and that type of injury can ordinarily be addressed through back pay or monetary relief if the petitioner ultimately prevails. For prong 3, the balance of equities, the court does look at the Gilbert case that the court brought up earlier in the hearing about how the government has an interest in suspending those with police powers when under criminal investigation, and that the Supreme Court did uphold that due to the fact that the government does have an interest in this. I do think that line of logic would also apply here. I can understand. I think the petitioner made some good arguments about some possible exemptions to that and why it may not always be here. But for a preliminary injunction, I think that the government has a legitimate interest in ensuring that the people policing the streets are have the proper character and fitness to do so. So for the balance of equities, I do find that it is slightly weighted in the favor of the government, and I would say for the public interest, that's certainly the same thing. I don't think we want police officers who may be committing crimes or doing some other things that they're not supposed to be on the streets policing the law, if that's in fact what's happening, and that's what's been alleged to happen according to the Attorney General's office. Whether that criminal investigation is legitimate, whether there's some other issues going on, which the petitioner mentioned, I don't really know. It's not really for me to decide, but just based off of everything taken together, at this time, I'm going to have to deny the motion for a preliminary injunction. Do any parties have their questions? Have any questions?
Yes, I have a question.
Sure. What's your question?
How can you say that me losing my well, I have multiple questions. My first one is how can you say that me losing my lease agreement and being homeless on the streets is not irreparable harm?
It's a
How
I already said that it's quintessentially an economic
well it's not
harm.
because that can't be repaired. Can you repair a terminated lease agreement that you probably can't even ever get back again?
Okay, but that doesn't mean you're not going to have any place to live in the future ever again. That's irreparable.
Well, that doesn't matter. What matters is that I don't have a place to live.
Yeah, and
I,
whether you
I
like
think I think you're
it's
basing it.
quintessentially an economic
Well, I think you're basing it
hardship.
on that Supreme Court case where it says that the loss of the loss of wage does not necessarily always constitute irreparable harm. But like I said, there are extraordinary cases where it does, and one of these is the extraordinary cases. The court itself said that
I'm also looking at this Fifth Circuit case where it says that the in a preliminary injunction when there's monetary damages, when monetary damage is the irreparable harm and any consequences that result from that. The one that they cited in here was the repossession of a vehicle that was that they couldn't get to work because the vehicle was taken away and they couldn't and they lost their job and the court denied relief on that grounds because it's still an economic harm and that the damages
that's completely different from a living
were
situation.
imposed were economic and that they could sue later and have their car restored and the back pay that they would have received and their false term it's downstream from the lost wages. That was the court's holding there. So
But
that's
what about okay? So the court found that there's a property interest. That public employees have property interest in employment. If you find that there's a property interest in employment, and the court recognized, even by admission of the DOJ, that I was not given any pre-deprivation or post-deprivation hearing on that, how can you justify that there's not a clear showing of being able to succeed on those merits when there's a property interest and you're being deprived of it without due process?
I don't understand your question. What is it?
What? Did you get what I said?
I'm not finding either way that there's okay. Do I need to read this again?
Well, are you saying that the statute I cited does not create a property interest?
I'm not saying either way. I'm saying that there's no clear showing.
Okay, well, it does create a
Ridgeway
property
requires
interest.
a clear
That's the
showing.
thing.
There's no clear showing. It's like kind of a 50-50 for me right now. I haven't read all these cases in
I mean,
full.
you can read it. You can read it analogous to the justices and the federal judges clause in the U.S. Constitution. Absolutely analogous to that, and the way you interpret it and read it, where they're appointed for a term of good behavior. Absolutely analogous to that, and to the irreparable harm thing that you said. Okay, sure. Let's say that let's say for the sake of the argument that me being homeless doesn't constitute irreparable harm. But what about the deprivation of constitutional rights? As I probably cited like 10 paragraphs worth that of multiple circuits in everything holding that it does constitute irreparable harm, and even that you don't even need any further showing of that other than the deprivation of constitutional rights. So I know the court said whatever about irreparable harm, but you never analyzed that under that.
Okay, all right, that's actually a fair point. All right, let me hear from the state first. I'm gonna come back to you, I promise. But yes, Mr. Feelings or Mr. Zalas, what are your questions?
Yes, question, Your Honor. I'm wondering if we can enter a further preliminary finding at this time for Mr. James Garday tagging me in the general Discord chat and saying, quote, "You're a disgrace to the legal community. Shame on you."
There's nothing I can do about that.
And, okay, I'm not going to push it. It's not that deep. I hear the arguments that the petitioner is making. I don't think that they hold that much weight. The law, the controlling cases are pretty clear. The the harms that are downstream from the economic harms are still economic harms. I don't think that there's sufficient background to try to change that analysis at this point. I also don't think that it does anything for the petitioner because he still fails to meet all the other prongs as well. So, I don't think that we really need to be here for another 30 minutes arguing about this. I wonder perhaps if Your Honor would, in the name of judicial economy, of course, proceed on to the show cause hearings. And if Mr. Gardai is upset about this, then he can file an appeal.
You can't file an appeal for this.
You can't appeal preliminary injunctions, but
he could try.
Nope, no,
He
thank you.
he could try, right? But that's
He could
not
try.
gonna go anywhere.
But here's the other thing, Your Honor, is at the end of the day, it is a preliminary injunction hearing. His case is not dead in the water. He still has, all the opportunity for all the normal pleadings and the showings of evidence at trial. If Mr. Gardai is in fact correct, he will be ruled in the favor of, and he will receive adequate economic relief.
Well, not really.
There's
not
no
in the
reason,
administrative courts.
Your Honor.
Do not interrupt him. Oh my God!
I'm sorry.
What is this? Time number 7? Really?
That's time number 3.
I don't think so.
Your Honor, yeah. I don't think that this kind of discourse is doing anything for us right now.
Yeah, I would have to agree. So, Mr. Gardai, I think
Well, you said you would answer my questions.
that's what I'm doing right now.
Well, I think in analyzing the preliminary injunction, you have to answer the question on whether public employees have a property interest in continued employment under the statute, which they obviously do.
I don't think that I have to make that finding now. That's certainly a finding I'd have to make on a dispositive motion or a trial, but that's not something I have to do now.
Your Honor.
Notwithstanding that, I still think that the government has a legitimate interest in this, in suspending employees, and that the public interest weighs against this kind of thing, and that there's no clear showing either way. If we have to have an hour-long debate about having me read, I mean, you should see the number of tabs I have open with all the cases that both sides have cited. Okay, it's very extensive. There's a lot here. It's getting pretty complicated. I don't think that there's a clear showing either way. I don't think there's a clear showing by you that you would prevail. I don't think there's a clear showing by the state that they would prevail. I think it's pretty 50-50 right now. I mean, there's no clear entitlement to relief either way. I think that whether these property interests suffice in this kind of, it's a little bit up in the air right now. There's no clear showing either way, right? I think that this is going to be very interesting and intellectually, enticing when we get to dispositive motions and we, maybe a motion to dismiss or alternative summary judgment or trial or what have you. But
point of order.
The point of a preliminary injunction is to decide whether there has been a clear showing. That's part of the Winter case that we're all here for, right?
Point of order.
This is not the Senate, okay?
Well, it's serious. I think you misconstrue these proceedings because this is an administrative claim. There is no trial or whatever. There's an administrative claim, and there's the opposition, and there's any further briefs by discretion of the court.
You're correct. So I guess we'll decide what happens then when the court makes its fact findings, or rather the hearing board made the fact findings when the court makes their conclusions of law. That's fine. We can handle that then, and I will be writing a lengthy opinion, whatever way that is. But honestly, right now, I don't even know how to feel about it. Right?
Well, can we at least get it docketed first? Because that was set to be done an hour ago.
Yeah, we'll have it docketed, okay? But in the meantime, it is the 6th day of April 2026. The Superior Court of Ridgeway, sitting in Fort Ridgeway County, having read and considered the brief submitted by the petitioner and heard the arguments of counsel and examined the citations given herein. The petitioner's motion for a preliminary injunction be and hereby is denied. Okay. All right, but good job, both parties. You definitely gave me a lot to think about. We're going to proceed into the show cause hearings now. I guess we're going to.
Why was Zolas uncuffed, sir?
Yeah, good question.
I'd like the court to make an inquiry on whether Deputy Novich is rogue.
Okay. No, the court's not going to do that. And the court's going to enter another finding of contempt.
For
that.
what? For asking for him uncuffing him for no reason?
No,
How?
that was a fair
It's a
That was
question.
a fair question.
It's a question if you can make a finding of that. How is that contemptuous?
That was a fair question to ask. What was not a fair thing to say is to make a finding that I should declare my bailiff rogue. That was the
How
problem.
is that? That's not contemptuous. I mean, you're
Your Honor.
crossing the line here. You're crossing the line here.
Your Honor, I respectfully move and ask that the court issue a gag order to Mr. Gardai.
Okay.
Not's feelings isn't supposed to be even the counsel. He represented me, and he's a shame and disgrace to the bar and to this legal community.
Okay, that's another finding right there. Shame and disgrace to the bar and the legal community. That's just.
I mean, come on. The guy is pushing 40 and still on this platform.
Okay, that's another one. Do you want to go for another? You want to go for another?
Oh my god.
Absolutely.
Can we just begin the
unbelievable.
show cause, please?
Okay, you know what? I'm doing these separately. Novich, put Mr. Garday in lockup. He needs a couple minutes to cool down.
Why can't I go first?
Because you're clearly upset and you need a couple minutes to cool down. I don't
Your
think
Honor, I
it'd be a
moved
good
him to
idea.
the audience. I moved him to the audience so he can cool down.
I think if I held his hearing right now, he would just get. I'm doing it for his own good. He would keep putting himself in contempt over and over again. So he can take a couple minutes to cool down. Okay, Mr. Zolas, you are appearing before this court on an order to show cause after multiple preliminary findings of contemptuous conduct have occurred, including your repeated insistence in interrupting both this court and opposing parties when making arguments, making insults to opposing parties, and failing to respect the authority, dignity, and the authority and dignity of this court as is required of all officers and all persons appearing before it or coming inside of it. Do you have anything you'd like to say to this court as to your conduct and why I should not sanction you or hold you in further contempt for your actions?
Yeah, Mr. Chen. First off, I would like to just sincerely apologize for my conduct before the court today. This is unbecoming of me, and I understand this court's expectations and how they must be followed within a court of law, Mr. Chen. I can assure you, from my last previously interruption, which was a little bit ago before James's
has
other
started.
ones,
I don't know what that was. Keep going.
Roommate, you were about 3 hours late.
oh, it's audio transcription to a channel,
Oh.
Oh, thank God.
which we had
I
that.
tried to get that started earlier. I don't know why that didn't work.
Would have been nice to have it a little bit earlier, but it's okay though.
We've been
let
audio
me
recording,
continue
so
here.
it's fine. Yeah, please.
I understand how serious this court is and how it must be treated, especially when we are in a public forum, as duty court is. I understand my interruptions and my actions. I would just like to inform the court that I have, as of before today, I have not been ordered to show cause before this court. I'm a upstanding member of the bar, and it was never my intention to undermine your authority within this courtroom. And I would just like to ask that you consider my apology statement and my acknowledgement of taking responsibility for my actions and my overall commitment to moving past this and serving my role as a state attorney within the court honorably.
The court accepts and thanks you for your apology. The court would just what's given the court a little bit of pause here and is very concerned about was one, the number of times that the court needed to make preliminary findings, and two, the fact that the court needed to order the sheriffs in the room to put you in handcuffs in order to get you to stop. The court will acknowledge that once it ordered you into restraints, that you did stop your behavior, but the fact that it needed to even get to that point is extremely concerning. Do you have anything you want to say in that regard?
I'm sincerely it might be coincidental, but I was planning on halting my interruptions before I was handcuffed, but of course I was handcuffed, so now it looks very coincidental. But I would just like to reaffirm my statement, and I'm overall sincerely I am very apologetic to this court, and I can assure this court that my conduct moving forward will definitely be honorable, and it won't ever again reach